county district attorney in our nation's history has issued criminal process against the sitting president of the United States, and for good reason. The Constitution does not allow it. Temporary presidential immunity is constitutionally required. The decision would allow any DA to harass, distract, and interfere with the sitting president. It subjects the president to local prejudice that can influence prosecutorial decisions and to state grand juries who can then be utilized to issue compulsory criminal process in the form of subpoenas targeting the president. This is not mere speculation. It is precisely what has taken place in this case and with this subpoena we challenge.
You don't argue that the grand jury cannot investigate the president, do you?
We have targeted the utilization of the temporary immunity here to the subpoena. That's correct.
Well, in other words, it's okay for the grand jury to investigate, except it can't use the traditional and most effective device that grand juries have typically used, which is the subpoena.
Counsel, it seems that you're asking for a broadness of immunity that Justice Thomas pointed out is nowhere in the Constitution. I'm not sure why he's entitled to more immunity for private acts than he should be for public acts.
Well, he's the President of the United States. He is a branch of the federal government.
We only give judicial officers and congressional officers immunity for acts within their official capacity. If they don't, if judges sexually harass someone, we've said that's not within judicial functions, they can be sued. If congressmen do the same thing, they can be sued.
We're asking for temporary presidential immunity. There are hundreds of members of the United States Congress and 100 members of the United States Senate. There is one president.